Allegations of bias, a lack of independence and impartiality, and any feared infringement of fair trial rights are accordingly not to be decided under the rubric of a special plea that the prosecutor has no title to prosecute. Title to prosecute is confined to the locus standi required of prosecutors and the regularity as regards their appointment or any additional authorization that might be required. In this latter regard, I'm thinking, for example, of the provisions of the Prevention of Organised Crime Act, which requires special permission or consent and authority in respect of racketeering cases. What an accused cannot achieve is to challenge an alleged lack of independence and objectivity or bias or a similar complaint under Section 106(1)(h). Any challenge involving an alleged lack of independence and objectivity or bias or a similar complaint, as alleged by Mr. Zuma, should have been raised in a substantive separate application for the removal of the prosecutor. Such an application had apparently been pursued in Porritt and was, by agreement between counsel in that matter, considered before the Supreme Court of Appeal, but dismissed on its merits. Similarly, in the matter of Smythe, being the example mentioned by the Supreme Court of Appeal, I beg your pardon, as an instance where a prosecutor can be disqualified on the ground of bias or an apprehension of lack of partiality, was decided on the basis of a separate application. In the present matter, there is no such application before this court for adjudication. The sole issue, as I said at the outset, is whether the special plea in Section 106(1)(h) has been established. I conclude that Mr. Zuma's complaints, even if taken at face value, do not affect the, quote, title, unquote, given its correct meaning in Section 106(1)(h) of Mr. Downer to prosecute. I also conclude that there's no basis to assign a wider meaning to the word, quote, title, unquote, to include instances of a lack of independence and impartiality or bias on the part of a prosecutor by developing the law in terms of Section 39(2) of the Constitution. There is no need for such development, as adequate remedies already exist in our law to cater for the situation where the fair trial rights of the accused would be infringed or threatened. The special plea therefore falls to be dismissed. Accordingly, the provisions of Section 106(4) also need not be considered any further.